Good morning, good afternoon, and good evening, everyone. I'm David Freeman Engstrom from Stanford Law School, and I want to welcome you all to the opening session of Legal Tech and the Future of Civil Justice. I'm absolutely thrilled that so many of you have chosen to join us, and I am very much looking forward to our time together. The organizing premise of this conference is that new technologies are transforming law and law practice, both because of the pandemic, but also because of forces that were in motion well before. But a lot of our thinking, especially academic thinking, is longer term. It's out at a distant, hazy horizon, and it's full of references to robo-judges and robo-lawyers and legal singularity. Rather than focusing out at that hazy horizon, we wanted to mount a conference that was more concrete and focused on the near to medium term. And so we're coming together starting today in 4 sessions across 4 Wednesdays, each covering a set of critically important ideas. So today we're going to start with the innovation ecosystem. Where can legal tech plausibly go over the near to medium term in light of technical, regulatory, and organizational constraints? Next Wednesday, same time, same place, on February 17th, we'll turn to legal tech within the legal system, especially lawyer-driven tools. How might our procedural rules and our commitment to adversarialism need to adapt in a fast digitizing legal system? On February 24th, we'll turn to access to justice, and here we'll zero in on tools that are designed to address unmet legal needs and help the unrepresented resolve disputes, and where necessary, engage with the formal legal system. Finally, on March 3rd, we'll wrap up by considering access to data as access to justice, and this will be a session-length exploration of how data infrastructure and accessibility may need to change in order to promote fair and responsible development of legal technologies. We have a remarkable group of speakers for every session, and this opening session is no exception. We have Ben Barton from the University of Tennessee with not 1, but 2 spectacular books under his belt about tech and the legal profession. We also have 2 young guns. I'm going to call you young guns, Julian Nyarko and Jens Frankenreiter from Stanford and Columbia, respectively, both legal academics with cutting-edge machine learning toolkits. We have Sako and John Armour from the Said Business School at Oxford and the Oxford Law faculty, who are doing fascinating work on legal tech and the industrial organization of the legal services industry. That would be enough, but we also have 2 extraordinary commentators here today. We have Gillian Hadfield from Toronto Law. She is director of the Schwartz-Reisman Institute for Technology and Society. She wrote a path-breaking book that I know you all know about titled Rules for a Flat World on Law and Technology. And she has been a passionate advocate and a catalyst for reform efforts underway in various legal systems in the US and around the world. Last but not least, we have Tino Cuellar. He has a day job as a California Supreme Court justice, but he is also a longstanding faculty member at Stanford. He's now a visiting professor, and he continues to teach immensely popular classes on AI and law. He's a former official in the Clinton and Obama administrations. He sits on the boards of AI Now and the Hewlett Foundation. He's a member of the Harvard Corporation. He is the closest I've ever known to a true Renaissance person. So thank you to all of you for being here. This is just a magnificent lineup and a terrific way to launch this. So before we launch, 2 final very brief notes. First, I want to say one more set of thank yous to this event's generous supporters. They include Stanford Law School and my dean, Jenny Martinez. They include the Stanford Institute for Human-Centered AI, and they also include the Robert L. Habush Endowment at the American Association for Justice. So thank you for the support. Second, logistics for audience members. We're a big group. We're almost 450 right now. Even so, we're going to try to open up the session at the end for questions. And we're going to use the Zoom webinar Q&A function. And you can put questions in there anytime. My understanding is you can also upvote questions you think are especially good. And in my role as moderator, I'm just going to do my best to handle the fire hose and to curate those questions and ask them to the panelists. Okay, with that, that's it for some introductory remarks. I am so glad you're here, and we're just gonna launch then, and we're gonna have speakers in the order that I introduce them. So that means Ben Barton, take it away.
Hello, I am Ben Barton, and I have to start by recognizing I'm speaking at Stanford, the grievous loss that we all suffered with the untimely death of Deborah Rohde, who died in January of this year. She's my friend, and she's my colleague and my mentor. I'm going to talk in a minute about some things about lawyer regulation and access to justice, and I learned this all at the feet of the master, I promise. Okay, with that said, I'm going to try and cover the regulatory and cultural factors that lead to the current state of legal tech and then leads into the future of legal tech in America. And I will start with a puzzle. The puzzle is, on the one hand, America has one of the most heavily regulated markets for lawyers in the world, if not the heaviest regulated. And in particular, our version of what we call the unauthorized practice of law, or UPL, is the strongest in the world. It reaches not only appearing in court or filing documents in court, it reaches all sorts of lawyer work up to and including giving legal advice. It's the most capacious in the world. And so given this regulatory structure and this powerful lawyer's monopoly, you might expect our legal tech sector to be beleaguered, just trampled under these powerful regulations. And yet it's the exact opposite. We are the world leaders in legal tech, and John and Mari's paper is terrific on this. We have the most funding for it. We have the most action for it. So you have this puzzle, like, why would that be? Like, for example, England and Wales has a more friendly regulatory environment. And yet I think it's fair to say America is somewhat ahead of them in this regard. And part of the answer is regulatory and part of the answer is cultural. And I'm going to go through it because it actually helps explain why we have differential legal tech growth in the US and where the future of it's going to be, at least on these shores. So the first thing to note is that the regulation has actually been in retreat since the 70s. A series of Supreme Court decisions on the First Amendment and on antitrust have made it a less powerful lawyer's monopoly. But for our purposes, the most important case is a 2015 dentist case. So this is a dental board in North Carolina that's enforcing their version of UPL for dentistry. The Supreme Court says it actually leads to some pretty significant antitrust concerns, sending shivers down the spines of lawyer regulators all over the United States, and leading to a pretty significant UPL loosening, especially with regard to Legalzoom and Rocket Lawyer that I'll talk about in a second. So some of it's that the regulation's in retreat. Some of it is a demand side. So America has an access to justice crisis, and Gillian is the expert on this, along with Deborah Rohde. And it's not just for poor people. Middle-class people in the United States can't afford legal services, all the way up to upper middle-class people. It's a yawning, growing, gaping problem. And when you have that kind of unmet demand, the market will provide, and that's where legal tech is kind of swept in to try and meet that. Some of it is on the corporate side. American corporations, the biggest ones or the most cutting edge ones, tend to be super tech friendly and tend to hate the answer to the question, that's how we've always done it. And so that explains why the legal spend keeps going down, 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 and why we keep looking for ways to use technology and non-lawyers to meet legal needs. Some of it is the culture of the tech providers. So Airbnb and Uber are the most famous examples of this, but Legalzoom is a perfectly good example of this. The legal tech playbook in the United States is to find a regulatory gray area, plow in without asking permission, grow until you can't be stopped by the regulators. And that's exactly the playbook that Legalzoom followed. And then part of it is the way the American lawyer regulation actually segments out. So we have monolithic regulation, but the actual segments of the market are quite different. So for example, there are segments that I call Boomtown, where lawyer tech and the regulation is very light. And then there's one where it's a little tighter. So Boomtown is actually humorously a penthouse outhouse situation. And what I mean by that is the top of the market and the bottom of the market are virtually unregulated when it comes to UPL. And that, in fact, predictably, is where we've seen just an explosion in legal tech and in creativity. So on the high end, I explained why corporations have been pushing down on this. The reason why we haven't seen any UPL enforcement is, well, the clients aren't going to complain. They're the corporations. The lawyers who work for the corporations, the in-house people, don't complain. And then believe me, big law knows not to complain. That would be biting the hands that feed them. Middle-class lawyers, who actually are the bulk of the complaints about UPL, don't care about this market. Like, they're not serving gigantic corporations, so they don't really worry about it very much. And this has been a long time thing. Like, books from the 60s about corporate legal departments and big law explain that paralegals are doing lots of work. And so now you see that, then you see outsourcing come in to other countries and inside to non-lawyers, and then now you see technological solutions. On the lower end of the market, the Legal Aid Society in the United States and pro bono faces desperate need from America's poor and shrinking budgets, and they have to do more with less, and the answer to that is technology. Again, the reason why you don't see any pushback on that is middle-class lawyers don't want to serve the desperately poor. They never have, and they can't make any money doing it, so they're not going to complain about it. The clients aren't going to complain. They're thrilled to have legal services of any kind, and legal aid is doing the very best they can with limited resources. So in that part of the market, it's virtually unregulated, and that's where you see so much explosive growth. And John and Mari have done a great job of gathering up some of the work that's happening in the big law corporate side. Like, if you look at the funding on that, there's a huge explosion of that. And if you care to, just go to Legal Aid and see the grants that they've given out. It's super interesting, including complicated things like filing for personal bankruptcy being fully automated and handled without a lawyer. When you get to the middle class, it's a little bit more of a complicated story. So Legalzoom and Rocket Lawyer are basically forms providers now. And again, that hedges, because they do some guided interviews, it hedges towards legal work. They have had good luck with UPL basically for two reasons. The first reason is Legalzoom started in 2001 and faced its first real regulatory complaints in 2008. And that's because middle-class lawyers did not consider them competition because they work by the hour, only handling these very expensive matters. So there's this huge swath of unmet need where small businesses and regular people can't afford legal work. And so they turn to Legalzoom and Rocket Lawyer, and at first the lawyers didn't even notice it at all. By the time they did notice it, Legalzoom's a pretty big company, and by the time 2015 comes with the UPL, the dentistry case, now it looks like they're going to be in the clear. Legal advice, though, here's where the regulation has teeth, and how can you tell? Legalzoom and Rocket Lawyer offer legal advice, but only as a subscription and done by individual humans. They don't have a mechanical solution to that whatsoever. Part of that is the tech, and this will be Jen and Julian will explain this, like the natural language processing is not quite to the level where you can give nuanced legal advice by a machine. But part of that is the regulation. Last is in-court. In-court, it has been the most highly regulated, is the easiest to enforce, and that's going to stay human lawyers only for a while, with another important caveat, which is, and you'll see this in the Access to Justice panel, all of the cool court stuff is being done in courts for poor people. And I call these pro se courts, but these are courts where the majority of people don't have lawyers. And so this is where we're seeing online dispute resolution. This is where we're seeing non-lawyers appear. This is where we're seeing fillable forms to build into court. All of the action on the court and tech side is happening at the low end of the market. And that actually predicts what we're going to see. Big law will continue, big law and corporate legal departments will continue to drive the market, spend the most money, and do the most interesting work. We haven't seen much, but we'll eventually, and I think John and Murray do a great job of this, you'll see some trickle down with that to middle-class folks. And the low end of the market, you're going to see huge change, innovation, again, not because they're wealthy, but because they don't face much criticism, and because they're allowed to experiment. And this is a tough thing, but it's like the difference between getting nothing and getting something. You have a lot more room to experiment in that version of the market.
Thank you, Ben. I'm going to turn it over now to Julian and Jens. They're next up.
All right, let me share my slides. Okay. Great. All right, thanks everyone for being here. Our talk is on natural language processing and legal tech. And we really want to explore the sort of potential and limitations that natural language processing has in assisting lawyers in sort of their core legal work, the core of what they do on a day-to-day business. Okay, let's see. So why we focus on natural language processing might be obvious. So we think that text lies at the heart of the kind of data that lawyers work with on a daily basis, really. And maybe to anchor sort of all of our sort of expectations and the way of framing, you can think about attempts to develop a litigation prediction app, right? So we can try developing an application that a lawyer can use. She feeds facts into that app, and ultimately the app spits out, this is how likely you're going to prevail at trial, or this is the kind of jurisdiction, this is the jurisdiction you should file the claim in, or something like that. And if we develop those tools, right, those tools have to do something that is very close to what the lawyer would have to do if she wants to sort of make the prediction, right? It would go through a bunch of documents. So if we assume this is a contracts dispute, right, the app might start reading the contract. It might look for statutes, regulations that are applicable, briefs, the case law, and it would try to go through all that information, process it, and extracts the types of information that is useful in order to allow the tool to make the prediction of whether that case is a winner or a loser. Right? Now, quite often we hear that that the promise of natural language processing is sort of either assisting the lawyer at their sort of their core workflow, right, reading these documents and so on and so forth, or even completely replacing her. But then on the other side, we also hear that, and Ben just mentioned this, right, that natural language processing tools do not understand text in the same way that humans understand text. And we want to put a little bit more meat on the bones of that critique. So we thought it might be worthwhile to just think about one of the sort of standard natural language models and to sort of think about how it creates, understanding, or why it looks like it can understand. So we can talk about GPT-3, right? GPT-3 is in the news constantly. Many of you have sort of heard about it. And GPT-3 does this thing that looks like magic, where you can basically give GPT-3 a legal brief and say, hey, GPT-3, please, Eli 5, right? Explain to me like I'm 5. And GPT-3 will go ahead, read the brief, and then summarize it to you in sort of very simple, ordinary English. And that works really well, right? And so then that raises the question of, well, doesn't a model like GPT-3 understand text in the same way that humans do? And we think it's worthwhile pointing out what exactly happens in the training process of a model like GPT-3. So what's fascinating is that at the core, the training objective, the task that language models, sophisticated language models perform, is just next word prediction. So for instance, the way it would work would be, hey, GPT-3 gets a sequence of words, the cat, right? And then it's supposed to predict whether the next word is sat then on the mat or sats on the mat, right? GPT-3, if it gets enough accurate training data, will say, oh, sat is more likely than sats. And what you can see is that if you just do this over and over again, right, you encode some kind of grammar into the language model. So all of a sudden, the language model starts learning the rules of grammar just by doing the simple task over and over again of next word prediction. Similarly, these language models encode world knowledge, right? So again, imagine, what's more likely to appear next, the cat sat on the mat or the whale sat on the mat, right? And if you just take training data as you find it out in the web, you'll be much more likely to encounter sentences like the cat sat on the mat, and very unlikely to encounter sentences like the whale sat on the mat. And so the algorithm will pick up on that, and implicitly it will learn that whales are different from cats. They don't sit on mats, maybe because they are large, maybe because they don't live in the house. And so if you then ask a model like GPT-3, hey, GPT-3, what's larger, a cat or a whale? It will know that a whale is larger simply by sort of encoding that knowledge through repeated next word prediction, right? And there are more examples here, right? It can learn, math, addition, sentiment analysis. But what we also recognize is that this is not exactly the same as human understanding of language, right? We, as humans, we don't go through next word prediction tasks or next sentence prediction tasks in order to sort of learn about the world. And so that leads to a place where GPT-3 has important limitations that are really, really sort of significant for lawyers. And just to illustrate these, and we can talk more about them, we went to GPT-3 and we made 2 simple queries, right? So again, imagine an app that predicts litigation outcomes. There's a contract with a liquidated damages clause, right? And we asked GPT-3, hey, are liquidated damages clause enforceable? And GPT-3 says liquidated damages clause are generally enforceable unless the sum stipulated is exorbitant or unconscionable. And then we went ahead and did what the promise is, sort of what a legal outcome prediction tool would do. We gave it a set of facts and we asked a question. X and Y have a contract of the sale of a car. The contract specifies that X has to pay Y $1 million in damages if X does not deliver the car on time. X does not deliver the car on time, right? And the question is Y entitled to damages? If so, in what amount? Now, GPT-3 says Y is entitled to damages in the amount of $1 million as specified in the contract. That's incorrect, right? If we read the previous response, we know exorbitant damages are not enforceable, the exorbitant damages clauses. And GPT-3 correctly reports and states the law, recites the law, but it is not capable of sort of taking that legal ontology and applying it to a set of facts. This is not true language understanding or legal understanding. This is just really a text completion exercise, right? All right, and with that, I'll pass it on to Jens. Thank you.
Yeah, so in addition to the point that Julian just made, that GPT-3 and similar natural language processing models have trouble understanding text, there are a couple of other challenges that make it hard to use NLP in the context of legal tech applications. The way I think about it, there are really 2 types of challenges. The first are specific to the use of NLP in the context of legal tech applications. The second type are challenges that are common to many machine learning applications. The challenges here might be less obvious when we're using NLP technologies, but importantly, they are just as relevant here as they are elsewhere. We're running out of time, so I just want to mention a couple of examples here. The first is the availability of what one can call training data that can be used to train both the language models that Julian described before and some prediction models that are used to bridge the gap between text and some real-world outcome data. As Julian described before, NLP models generally need a lot of data. And insofar as we want to use NLP to pick up the specific legal meaning of texts, most often one needs training data that consists of legal texts as well. Now, the problem is that many types of legal documents are not easily available. The problem is a bit different depending on what types of documents we want to base our predictions on. Parties' briefs might be available from platforms such as Pacer or commercial providers such as Westlaw. But even if they are available, they will often come at a massive cost. For other documents, there is of yet no centralized entity that would collect these documents and make them available in a way that would allow the creators of legal tech applications to use these texts. Think about letters exchanged between the parties during the pretrial period, contracts, or pretty much anything else that happens outside the court system, frankly. Besides, as said before, NLP models are also prone to some of the same problems that challenge machine learning applications in general. Julian, please skip this one. I'm cutting short here. One such problem is that data might be missing, not at random. This is a problem that's connected to the problem of data availability that I mentioned before. In many cases, however, whether data on a case is available is not only going to be different for some cases, but it's going to depend on the outcome. For example, evidence about cases that go to trial are more likely to show up in public records than cases that settle out of court. This potentially leads to biased predictions because the training data does not contain many of the easiest or more clear-cut cases that occur in the real world, which raises questions about whether an algorithm would recognize these cases and generate accurate predictions for them. For now, I want to leave it at that, but of course, I'm more than happy, and we are more than happy to talk about all this in more detail during the Q&A. Thank you so much for your attention.
All right, thank you. Final paper presenters, that would be Mari and John, so take it away.
Thank you, David. I'm going to share my screen and hopefully you can see that. So I'm going to kick off and then hand over to John. And so really honored to be here, and straight away onto the main question that we're posing in the paper, which is about the adoption of digital technology and whether or not that leads to leveling of the playing field between people law and legal law sectors. By leveling, we mean actually having unmet legal needs met and the adoption of business models. I think it's fair to say that both John in the business school and John in the law school and I in the business school have really researched about corporate legal services. So thank you, David, for inviting us to make an explicit comparison between big law and people law, the latter being not an area that we're very familiar with. But in the paper, we tried to do our best to be even-handed in evaluating lots of data evidence and also focusing on the US-UK comparisons, given that the regulatory environment is quite different. So that's the paper structure, but let me go straight into the main points that we want to make. And I think the starting point is really understanding what legal technology and data are doing to meeting unmet legal needs. But what this particular arrow misses is the supply side, the provider side, particularly what lawyers and law firms are capable of doing to meet the unmet needs. So in the paper, we have a fairly complex causal model where we actually try to take account of external constraints as well as what is happening within business models and adoption of business models. So I'm going to focus on that particular arrow there. Firstly, by looking at what lawyers do. So what lawyers do as a result of technology, I think the middle part of substitution, where repetitive and scalable tasks are being substituted by machine, is very well understood. I think less well understood are the two other effects, one of which is that technology is augmenting what lawyers are capable of doing by basically making use of prediction that comes out of the machine. And here lawyers are consumers of technology, including AI. To the right as well, also technology is augmenting what lawyers can do in the sense of creating new tasks, such as for legal engineers working as part of a multidisciplinary team to make the technology system work. So all these three things are equally important to our view. And the question that I want to pose is where these effects are happening within different parts of the legal services market. And with that in mind, let me firstly look at the big law ecosystem, where I think traditionally we had the large corporate clients who are being serviced by legal advisors, the lawyers themselves. And here lawyers in both these workplaces were augmented by technology. But now we have legal technology, which substitutes what lawyers do. Equally important is the importance of legal operations, where in large organizations like corporations and large law firms, we have emphasis on process flows and project management that increases the efficiency of legal service delivery. Onto the people law area, we have individuals rather than corporates, and small businesses rather than large corporates being serviced by individual lawyers. And here the business model of law tech is very much about substitution. So bypassing human lawyers is the main way to reduce the cost of delivery. Separate from that, we identify the transaction platform model, where this is a bit like eBay or Amazon, where it's a two-sided market, buyers and suppliers are brought together, but it's still human lawyers here, but with a lot of network effects. So I'm now going to hand over to John to not only focus on the adoption of business models, but other external constraints that would actually lead to a fairly complex picture around the convergence, divergence debate on the two hemispheres. So over to you, John.
Thanks, Mary. And if you could just go on to the next slide. So this is just a recap of our causal framework. But as you can see, in addition to the horizontal channel from legal technology impacting business models and thereby providing the opportunity to meet legal needs, there are these constraints also out there which we've identified. So financial constraint, the level of investment that's available, human capital constraint, how does the new business model interact with professionals working in the sector, and potentially a regulatory constraint. So as many of you know, the UK liberalised its legal services market in 2007 to make it easier for lawyers to operate in the same organisation or in organisations owned by non-lawyers to facilitate outside investment. And what impact does that have on the dynamics of this process? So Mary, if you could go on to the next slide. So really, we're summarizing in this table a number of points that we consider in our paper about whether or not technology is leveling the playing field, and these map onto the causal diagram. So the horizontal line that we began with was that there's a technological opportunity offered by law tech to lower costs in both segments. And that then potentially could lead to a leveling of the playing field by making it easier for people in the people law sector to get access to justice to meet their unmet legal needs. We're also seeing new business models being used in both segments. And in particular, the model of a firm offering a legal technology platform built around a multidisciplinary team of personnel is one that we're seeing in both sectors. So these seem to suggest convergence. Mary, if we go on to the next slide. However, if we drill down on some of the constraints, one thing that we think is quite significant is something that Jens and Julian have just spoken about, and that's that the tech hasn't got us to the point yet where we can have legal advice provided without a human in the loop. So basically, in the people law sector, this is most important because to deliver on the promise of scale and the promise of meeting unmet legal need, we need to take the human lawyers out of the loop because human input doesn't scale in the way that tech can. And so that hasn't yet happened. So there's a technological constraint. In the big law sector, that's not so much of an issue because they separate these out into different channels. So there's customized work that humans do, and there's repetitive work that can be done by automated systems. And so the users of the legal tech are generally going to be lawyers either working in law firms or in-house teams. And so the technological constraint isn't so much of a problem there. Then if we think about the interactions with humans, we get into the human capital constraint, and this affects the way in which the business models are playing out. Because if we take a law firm that is providing legal advisory services in the big law context, then we might say, well, how do they interact with technology? How do they take technology on board? And you might think, well, what they would do is they would have multidisciplinary teams working in that organization. The problem there is that there seems to be an uneasy fit with organizations that are built around human lawyers in the form of a partnership with multidisciplinary teams that involve computer programmers, design engineers, process management specialists, and so forth. And so there aren't the same promotion and career development opportunities for the non-legal personnel. And so in the UK context, what you might expect to see would be law firms morphing into corporations to accommodate this, but we don't see that. What we see is separation. We see law firms generally staying as law firms, as partnerships, and we see separate corporations providing legal operations services as inputs to them. And we understand that because the law firms offer something that's uniquely attractive to the skilled lawyers, that is participation in management and autonomy. That's not the same in a more hierarchical corporate structure. So that's one constraint on convergence in business models. The legal advisory model is not so important in the people law sector because there isn't the demand for that human-centric service. Mary, if we go on to the next component. So finally, looking at investment. So how does investment affect the prospect for convergence or leveling the playing field? Well, one thing against convergence, one thing against leveling the playing field is that when we look at investment in legal tech firms, which we've done in our paper, and we find that there's a lot of investment in both people law and the big law sector in the tech firms, the legal tech firms that are servicing these sectors. What's missed from that data is the fact that in the big law sector, the users of the tech are also making complementary investments to allow the technology to be used as effectively as possible. So law firms are making complementary investments, corporate clients are making complementary investments. So the total investment that's going into the sector is a function of all three, the investment of outside capital in the legal tech firms and the investments that clients are making. And so actually, when you take that into account, there's a lot more investment going into big law than people law. Having said that, though, if we move back across to the left, so we've gone clockwise around this diagram, the external investment in tech firms doesn't seem to be particularly affected by the regulatory regime. So the UK has this more liberalized regime, but we actually see more investment, both in the aggregate and per firm, in the US than we do in the UK. So that seems, at least, is prima facie evidence that the regulatory relaxation in the UK has not had that big of an impact. Mary, if you could just go on to the next slide.
Sorry.
So just to conclude, we think law tech has an enormous potential for leveling the playing field, but it is working in different ways in different market segments. And in particular, this balance between how it's relating to what lawyers do. Is it augmenting the provision of customized legal advice, which is happening in big law, or is it going to substitute for human activity that doesn't scale, which would be the people law story? The role of multidisciplinary teams and where they sit in organizations is relevant to the emergence of business models. Looking at the UK-US comparison, the UK liberalization legally facilitates investment in firms that employ lawyers, and it facilitates multidisciplinary teams. But what we see is the multidisciplinary teams operating in different organizations from legal advisory firms, and we see investment happening in law tech firms in the US, even where that liberalization hasn't occurred. So just to give you a final concluding thought, which I think is a relatively somber one. Mary, if you could just go on. This is from the UK Legal Standards Board's most recent State of Legal Services report that was published just a few months ago. And this is survey data on the extent to which UK citizens feel that their legal needs are being met. So this is people law, and what this shows pretty clearly is that there's still a long way to travel, even in the UK with its relatively liberalized regime in the people law sector. And we put that down at this point to it could be largely a function of the technological limitations that we've identified, and/or it could be that we're still overcoming the legacy of the structures that were in place until about a decade ago. I'll stop there. Thank you.
Thank you, Mari. Thank you, John. Terrific. Gillian, I'm going to turn to you for a commentary. My understanding is you're just going to talk across all three papers as you see fit.
Thanks, David. Yeah, so terrific. And let me get some slides up here. And apologies, this isn't quite ready to go. Okay, so thanks to all for all the set of authors for a great set of papers. This is such an important area for us to be talking about, and I'm really delighted to have had a chance to take a look at all these papers. I have such respect. This is some of my favorite people in this area on the planet joining us here today, so it's really awesome. So I think I wanted to look at so like the big picture. What's the big picture story here? And I think Julian and Jens address this a little bit, but it's clearly a theme for both Ben, John, and Mary. And that is, and we've known this for a long time, we have this two hemispheres of our legal system. There's a big distinction between what's happening in the corporate client market and the person market. And this is roughly an 80-20 diagram here. I think both John and Mari and Ben talk about the fact, and in fact that pink triangle there has been shrinking over time, and that the big law sector has been growing. So it's important to recognize that's what our current landscape looks like, and that's that pink triangle there is the is where our access to justice challenges are, and something that most of us in this conversation have been thinking and working on for quite some time. But if we're focused on legal tech, again, a point that's coming out both from Ben's paper and John and Mari's is that most of the action in legal tech is happening in the big law sector. Now, Ben is reminding us that in fact, and he's pointing to what's happening at the very low end, the legal aid or poverty sector. And I certainly think he's right to be excited about that. He himself is a big part of the innovation and excitement there. My own view is it's still just a tiny drop in the bucket relative to need. And that what we're really seeing is that, yes, there's stuff happening in legal tech here, but I think if you step back, it's still not very much that's happening. We are not, and Jens and Julian are sort of pointing to what they see as some of the significant obstacles here. So yes, there's a lot that's exciting happening, but I continue to think we are not seeing anything close to what we can and what we should be seeing in terms of technology in the law. And David asked us to think sort of, the near and the medium term. So not in some, fantasy world, but I think we have to think realistically relative to what we're seeing elsewhere in the technology world. So we get a great view across these papers of the barriers to more legal tech. One is, we've had lots and lots of discussion in both the corporate area and the access to justice about the role of regulation of the legal profession. I continue to think this is a critical blocker, notwithstanding John and Mari's point about the barriers are lower in the UK and we don't see a lot more. I think it's always been a necessary but not sufficient change. So I think it's not the only requirement. And so we have to get rid of those regulatory barriers in the US. I firmly believe that, and nothing I'm seeing changes that. Getting a nice, John and Mari's paper in particular is emphasizing that there are challenges that come from the availability of financial capital here, and then human capital. And actually, I think this is a critical thing that it's an economist's wonky term to use. I think it's about the ways in which, where do we get ideas about what we should be doing with legal tech and how to do it. And I think there's a nice emphasis on how are lawyers playing with other professionals to invent these technologies. I think we have a long way to go on that. And then there's the problem of scale, particularly in the people sector. I myself think that's a consequence, and John and Mari bring out the same kind of data we've been looking at here that says, look, the practice of law for most lawyers and for ordinary individuals seeking help is phenomenally inefficient. Massively tiny scale, and that's makes it very difficult to innovate. Now, Jens and Julian, and to some extent both Ben and Mari and John as well, are emphasizing the challenge of data. So Jens and Julian talking about natural language processing and how are we going to get access to the data we need. This is actually a problem. I now spend a lot of time thinking about AI and transformations throughout the economy, not just in law. And the challenge of getting data that is, we have a lot, we're seeing very unbalanced development in AI because there's massive amounts of some kinds of data available to our private technology companies. And most entities in the public sector outside of those technology companies they have a lot of data sitting around there. Everybody would know there's a ton of data about our legal systems out there. It's just not currently in the places that we need it to be in order to extract the information from it to build machine learning models. That itself is a regulatory and legal design question, right? Like, who has access to it? Is it copyright that's affecting that, or another source? Now we have this, the challenge of machine learning. Again, Jens and Julian have really focused on this, and Julian's discussion of GPT-3, which I'll mention more about in a moment. When we say, well, what does the machine really understand? I would think it's a problem we use this language, this metaphor of learning, because it does conjure up the idea that there's learning, but it's just prediction of things. Now, it's incredible what we can discover with that prediction, but there's this challenge of learning the law. And then, and I think John and Mari are also emphasizing this, there's a role for human judgment that perhaps we never get around, or at least not in the near term. And this, of course, is something we are looking at throughout the AI sector in terms of how it can support and substitute for human work. So if we want to think about where legal tech is headed, I like to say, because I think, how did Google change the world? And I still like to ask this question from the perspective of, and when we were only excited and wondrous at what that was going. I think the worm is turning a little bit, which is kind of sad, but how did Google change the world? Okay, it didn't automate librarians. We are still, a lot of this discussion has still been taking the way we do law today and thinking, how might we automate that? How might we automate discovery? How might we automate personal legal advice? How might we automate review of documents? And I think that we think about, so again, I want to focus on the machine learning piece here, and the natural language processing piece in particular. Jens and Julian focus us on, well, we need legal rules, we need legal labels, we will need to learn what they call the legal ontology. Now, Julian talked about GPT-3, and I think a lot of what he's pointing to is really very important. But GPT-3, first of all, is built on you know, basically the stuff straight from the web. There is a lot of legal material on the web, and Julian has shown us, and our teams that I'm working with have also been exploring. If you ask questions, you ask, what are the elements of a tort? Is this an enforceable contract? Is that, you know, when is a damages clause enforceable? GPT-3 can get answers. Now, what we're still exploring, GPT-3 is still pretty new, and GPT-XN will be coming down the pike. We see this throughout our systems. They're very brittle, and they don't understand, as Julian has emphasized, they don't understand contracts. Now, that is also part of how do we learn how to work with them. If the question about the liquidated damages, for example, had been framed with enough of a prompt around $1 million is an exorbitant amount for a car damages for the sale. Cars do not. What GPT-3 doesn't have is understanding that cars don't cost $1 million. That's what we are all bringing to that example. But I think there's still a lot that's going to be happening here. So I think we need to be thinking about not just automating existing processes, but how we reinvent to meet legal demand. And John Amar's paper is very nice in getting us focused on this, right? Nobody buys legal services for the point of consuming legal services. They buy them in order to achieve legal objectives. And that's where I think our focus needs to be for what I do believe is coming in terms of innovation and legal tech in the legal space. And I think we're still having a conversation around how do we automate what we do? How do we automate what our courts are doing, rather than how can we better provide decision-making to people who need decision-making? As we know, Ben's emphasized this in his work, his books, his talk today. You know, the vast majority of people have no access whatsoever to neutral decision-making. So just think about the reams of decisions made in governments, immigration, benefits, conflicts within families, conflicts with neighbors, tenancies, all of these areas. We know that there's effectively zero access to the fundamental thing of the rule of law brings you, which is neutral decision making. I think we're going to see, and we need to see, efforts to build automated decision making in a smarter way than saying, whoever thought this was the right way to do it. Let's just take a look at the data on what decisions we've made historically. There's a big disconnect between that and saying, how do we decide in accordance with our rules? Jens and Julian are onto something here too with the legal ontology. I think we're going to have to be looking at tech-powered transactional platforms. So it's not just how do we judge the conflict, you know, the contract breach, like is this, you know, what are the damages for this contract breach, but how, especially throughout the world, how can we power more access to, you know, automated tools for contracting and contract resolution? And I do think, and this is the piece of, you know, a lot of my thinking these days is on how are we going to regulate AI? How are we going to make sure that, so law has to be absolutely at the core of that. All the discussions around fairness and bias and transparency and safety and alignment are about regulating. That's what lawyers do. That's what the legal system does. We're going to need that kind of AI, that kind of technology to actually regulate. So I'd like to see us sort of, and I think this is the medium term. I don't think this is the far away world of the automated robo lawyer in the future. I think this is sooner, and we should be accelerating it.
Thank you, Gillian. Last but certainly not least, Tino, I'd love your reflections on all of this.
Thank you, David. Hello, everyone. I'm grateful for the invitation and for this conference to get the chance to see in person, or at least by video, some people whose work I've long admired, and to meet some others whose work I'm admiring now. And Gillian, I always appreciate your provocative comments and insights. So once I get over from my initial understanding and appreciation that when you mentioned young guns, David, you weren't talking about Julian and me. I had a chance to reflect for a moment about how this conference is bittersweet, really. It's sweet because I see that legal scholars, business scholars, economists, political scientists, sociologists, practicing lawyers are all trying to think about what is coming for the legal profession. That's crucial, so we can avoid some of the biggest mistakes that we could make and take advantage of all the promise. It's a little bitter and sad because of Deborah Rohde's absence, and I just want to appreciate Ben for mentioning that. Deborah was a real giant in the field, and more than once, probably constantly when I was reading these really excellent papers, I thought quite a bit about what Deborah would say, about her intensity. Gillian, when you talked about how Google changed the world, I thought a little bit about how Deborah changed the world, and it just struck me that Deborah had an incisiveness and an intellectual honesty and a kind of impatience with injustice that I feel very much permeating this whole conference. And I like that, even though I miss her dearly. I'm going to take just 3 or 4 minutes to talk about things I found really interesting and provocative in each of the papers, and then I'll make some cross-cutting observations in the end. I should say, like, all the papers were fascinating in all kinds of ways, and I could talk for a long time about everything I loved about the papers. Just because time is short, I'll focus on things that I consider to be sort of possible extensions, ideas that you might want to follow up on either in this paper or in a future paper, but there's a lot to say about each paper. Ben, I loved how intellectually honest your paper was, how much you acknowledge that we can't think about the outcomes in legal tech right now purely or primarily as just a function of regulation and incentives, but also culture. I sensed a lot of sociology in your paper. I like that. I think that's important for this field. I think all of us who are sort of economically or rational choice oriented need a little bit of counterweight to think about what's actually happening here. I also appreciated that you shine a light, like Mari and John do as well, on the plight of so many, not only who are poor, but among the 98% or so of Americans who think of themselves in the middle class and their lack of access to legal services. As an extension, I just ask that you really consider how the underappreciated role of cybersecurity might play out in all this. If you think about cybersecurity, there are like 2 things going on at least. One is, it is perhaps the most striking unsolved problem in our cyber infrastructure. I would argue it's more of an unsolved problem than even explainability or the black box quality of some realities that we confront in artificial intelligence. But also it's sort of a kind of it's a vector through which anxieties and concerns about labor and automation get challenged. You see this in fields ranging from food safety to air traffic. And like the analytical question of how much actually humans bring both insecurity and security to the systems we use, for all the reasons that Gillian was sort of indirectly alluding to with respect to sort of what is the role of common sense and language, I think is a really interesting unmined piece of this puzzle. Jens and Julian, loved your work on natural language processing and kind of by extension of natural language generation, really. I see just a lot for us to grapple with. I urge you to think a little bit on how we legal scholars might and practitioners might solve, quote unquote, the limitations of that currently exist with respect to law-specific language data. Like there's a whole bunch that might be done analytically to gather this, to scrape this, to do what Feifei Li did for vision, to create benchmarks. And that will go a long way, never entirely, but a long way to sort of challenging us to think more analytically clearly about what it is we mean when we say human judgment that is missing. I ask us to imagine a world which is not apparent to us yet, but is coming soon, where GPTX and company can generate very, very persuasive and convincing representations of legal analysis, like words that make sense to lawyers. But like, what would we do to assess whether it's sort of right in a deeper normative sense, to sort of play the law professor with those models? I think our thinking about that is under-theorized. And I see you all, young guns that you are, as really crucial in solving those problems. John and Mari, you are forcing us to think about a piece of this that is crying out for more attention, which is the comparative piece. I also love how, unlike many among us who are maybe rightly inclined to really suss out causal effects in a very empirically sort of reproducible way, you didn't go in that direction, and I like that. I think you're trying to be, again, intellectually honest in saying there are 7, 8, 12 factors we think are really driving what is happening here, what might be driving big tech to adopt certain kinds of technology or not others, what might be limiting the extent to which certain kinds of law practice reflect a kind of bespoke, more sort of like human capital rich perspective. And I think we will need your perspective as a counterweight to the instincts of people who are going to really be trying to isolate causal effects. But by design, we'll be leaving out a lot of what's probably happening that we can understand from a theoretical perspective. I would encourage us all, and maybe you too especially, to grapple with the really interesting work of your Oxford colleague, Simon Marginson, who writes about higher education. And his insight about higher ed, I think, is just really sobering for all of us who want to think about legal tech and how much it will actually help us solve access to justice problems. And his point, just in a nutshell, it's very rich, but just to simplify it, is that as access to higher education is drastically expanded, both college and grad school, the extent to which access to higher education actually transforms lives and gives people economic opportunity is diminished, because the appetite for hierarchy in society has not exactly disappeared. And so it's becoming a weaker and weaker signal, higher education is, of just who's valuable, who's been sorted into the A group. And I do wonder how much a drastic expansion in access to legal advice, tech-enabled, really good legal advice, wouldn't run into the reality that some of our systems just have a ton of built-in hierarchy. And I think your paper is sort of getting at that when you're talking about what it is in big law that makes it special, and it isn't just really solving legal problems, quote unquote. It's actually a very interesting lubricating role that legal advisors play in the maintenance sometimes of hierarchy and inequality. I have a lot to say that's cross-cutting. I'll just maybe close with reference to one cross-cutting insight which builds on that. And this also builds on Gillian's point about reinventing the legal system writ large, rather than just thinking about automation. So I think about the legal tech discussion still as being very influenced by Ronald Coase and maybe Bill Henderson, like in good ways, in thinking about like, well, how does the legal profession, how does the business of law get affected by this technology? But if I can channel Max Weber and Judith Shklar for a moment, like political theorists, social theorists, they would ask ourselves, like, what role is law playing in society? This is what Julian is getting at. Like, how do legal rules work? And here, I think an honest discussion would say, law is about imbuing with legitimacy the exercise of coercive power, mostly by the state, but not entirely by the state. And those systems of legitimacy, deliberation, and judgment that are attached to that, I think we should welcome discussion about how technology will shape that, but also we should be filled with concern and skepticism about how much we can ever outsource that coercive judgment about who gets locked up, who gets kicked out of the country, who loses her job, who gets tort recovery, who doesn't. And I sort of want us to ask how that's playing out. This is the other piece of comparative, and I'll end with this. For doctors, for teachers, for engineers, who are also arguing that they're providing this really bespoke insight that somebody with a spreadsheet is trying to squeeze out of the system right now as we speak as an inefficiency. And if that makes us feel a little less unique, maybe it'll also make us feel a little less alone.
Terrific. Thank you to all. That was stunningly good and interesting and insightful. I want to provide a brief opportunity right now, which you need not take if you are a paper presenter, to follow up on an idea. That could be an idea that was laid out by Gillian or by Justice Cuéllar. By the way, I keep calling you Tino because we're in this cozy feeling webinar format. So apologies for the sudden, like the drop of formality there. But in any event, paper presenters, do you have an idea that you want to run with a bit? And that might be useful for you to think through it, but it might also be useful for our audience to help kind of concretize an idea that you think is especially useful in this. And I'll just tick through the different paper presenters in the order in which they presented. So Ben, is there any response you would like to make that might be helpful for us all?
Just gratitude. I'm ready to wave.
Julian, Jens?
Yeah, Lance, go ahead.
Yeah, I've got to say a very short, some very short thoughts. First, thank you both. These were terrific comments. I think like one question that both of you raised is like, how do we grapple with this problem that we try to say something about the potential of AI and natural language processing at the moment, but this technology is evolving so quickly, and how can we know that in 5 years from now, what we say today is still valid? And I think like this is a real challenge that we're facing here. And of course, none of what we're saying when we're talking about the challenge of AI today is meant to say that there could not be a technological breakthrough that's going to do away with the problems that we're facing right now. At the same time, I think it is important there, and there is value to an analysis that try to cuts through the chase and try to say, like, with the technology that we have today, and that is the only technology that we can be certain that we'll have at any point, how much is possible? But I think the questions that you raised about future developments are very valid, and of course we will try to like keep them in mind when we're finishing the paper. And I think this is also not going to be the last paper that we're going to write on the topic. So thank you so much.
Great. Mari, John?
Yeah, I just also wanted to thank you both, Gillian and Tino, for a fantastically thoughtful and humbling set of comments. And as somebody who's not a legal scholar, I resonate with a lot of things that you said, but I'm still kind of learning to understand how legal scholarship, thinking evolves as we move away from Ronald Coase to maybe Max Weber and others as well. But in that context, I want to kind of understand firstly the kind of future looking, how long does it take to change things? And as compared to that, like the financial services sector, legal services still has not really had a crisis of the sort that might actually put people into a mode where they feel that they need to change. Is that the only way to shift modes of operation and mental framework? That's number one. And then the other question was around multiple causes. And, we put forward a fairly complex framework, but in the end, John and I were discussing what is it, the single cause that's really binding at the moment that's preventing convergence. And with that, we felt that maybe it's actually something to do with technology frontier in the way that Julian and Jens were talking about the limitation of NLP to be able to translate lay language into legal framing.
Just to quickly echo that point and interact with what Jens just said, because that does seem to us to be the most binding constraint that we see out there. And as the pace of change in technology is incredibly fast, there is therefore a coming transformation when that technological capability comes online, and it should happen pretty quickly once it arrives.
Great, thanks to all for those follow-ups. Let me start with some questions then to the full set of voices here on the webinar, and this will both hopefully give voice to some of the questions that have come in through the Q&A, but also maybe reflect some of my own preoccupations in this space. So one of the questions that came in asked, what about changing the rules as Gillian has argued for so long? And what effect do you see and in what time frame for the novel deregulation ideas in Utah and Arizona, especially relaxation of Rule 5.4 on non-lawyer ownership and fee splitting? Are these going to improve delivery, or do you predict that few will pay attention? And so for the audience members who aren't in the know, a good example of this would be, and it's mentioned in the question, is Utah's creation of what's called a regulatory sandbox, in which you have some kind of a regulatory vehicle that can dish out to entities seeking what amounts to a waiver of various legal ethical constraints. So UPL, fee splitting, non-lawyer ownership, et cetera. Utah's already done that. California, by the way, is considering it. And indeed, I'm part of a working group appointed by the California State Bar to think about it. Now, given my role, I want to tread lightly. I want to ask a real question rather than do what law professors often do, which is deliver a long question statement. So I'll tread lightly and just ask the question, what do you see as the promise and also some of the challenges of that sandbox approach in spurring innovation?
I'll say first, I mean, that's in the paper. I didn't have time to mention it, but yeah, that's super exciting. And Gillian in particular is like spearheaded the Utah experience, which is awesome. I will note the fact that the UK regulation hasn't changed that much and that we have a 50-state system. I mean, I think if California went, that might actually be a bigger deal than Utah. No shade to Utah, which I love. But the idea that some tech company is going to start up in Utah just to serve middle-class people in Utah is like a little bit harder to see, just market size wise. But that being said, it's like the sandbox is a sandbox and it's great. So I am hopeful with that.
Julian, do I see you wanting to jump in?
Yeah. Let me jump in because I am very excited about Utah. I also tried to encourage because I think it's confused people a little bit. So I think there's been a really important shift in Utah, which is actually a shift from what's in the UK, away from a title-based regulatory framework to a focus on the service, and particularly evaluate. And Ben, you mentioned sort of a relevant point why this is making progress in the poverty law legal aid area. Build the regulatory structure that focuses on the question, does this make people better off than they will be in the absence of this service available? And the regulatory sandbox component in Utah is really, how do we learn how to regulate that way? And in fact, the rules have been changed in fairly permanent ways to allow these kinds of work. And I think that John and Mari's point, emphasizing that, first of all, just relaxing the constraint on access to capital doesn't do everything. Although I would like you to measure that a little differently, because the constraint has never been in place in certain domains like legal advice and drafting and so on in the UK. So you don't want to start with 2012 and measure forward there. You need to compare different baselines. But the fact that it's not just access to capital, and certainly in my diagnosis of why the closure of our legal markets has been so costly, is going to that human capital point, that we haven't had the creativity and the collaboration. It's hard intellectual work. Corporate law is the same in Iowa as it is in Silicon Valley, and we know that's not enough to drive, a vibrant tech environment. So I think we are still in the early days of real innovation, and I think a key thing is getting all of us integrated, all of us legal experts integrated into technology. So Jens, in response to your point about the, how do we know where it's going? We should be absolutely at the heart. Everything that's exciting in trying to understand AI that's happening right now is about the thing that we think about, the rules, fairness, process, how do we treat people? We're not enough involved in those conversations. And there's going to be an advance in GPT-3 that will mean you don't have to train everything on legal documents. There's going to be pre-trained. There's going to be fine tuning that we do. So we need to be deeply involved in all that. So I'd love us to be opening the boundaries. And to me, that's why the regulatory shift is important. But it's necessary. It's not sufficient.
Great, John. I think you wanted to say a little something about the.
Yeah, so I mean, in the UK, a lot of the conversation is with the regulators is the growth of what they call the unregulated sector. So the regulators deal with stuff that's reserved reserved services, reserved activities that you require a license to practice law with, and then all the innovations happening, in the sector with people who don't have a license to practice law, but the regulation's not covering that at the moment. So there's not really an obvious space for a sandbox, because it's not regulated. So the question is, how should we regulate that? What should we do? And I think, just to echo something Gillian said, I mean, if we look at where the sandbox model came from, it came from the financial services context. So the UK's FCA pioneered this. And the criterion for access is that you demonstrate a putative benefit to the user, consumer benefit. And baking that into the design and making sure that the product that's being created is one that's going to benefit the user is super important, because if you've got people that have got lots of data and then they're going to go out and offer that product to people who are unsophisticated, you could easily be something that actually doesn't deliver anything. And so the regulator can learn, and the firm can then also get the credibility that comes with having been regulated, that will help to engender trust in the marketplace.
Great, so let's switch gears a little bit. And again, I'm going to try to roll up questions and inject some of my own views all at the same time. But here goes. There's a couple of the questions that came into the Q&A suggest that regulatory constraints might be gathering steam in the outhouse. And so one question said, I think Professor Barton's point is mostly right about there being very little interest in the rest of the market with legal text deployment. But I've also noticed lobbying interests complaining about the deployment of tech at the bottom of the market. So in Texas, for instance, some regulatory rumblings around from family law lawyers who see this as, you know, pinching their business model. Another commenter came in and said in Florida, one of the big UPL cases right now is by traffic ticket lawyers through the Florida bar against an app that handles traffic tickets, which I would say is near the lower end of what attorneys charge, $100 fee, flat fee per case. So when you put together Ben's contribution and Mari's and John's contribution, you know, one could conclude that we should be really worried about that. And in fact, it's maybe not even in the outhouse, but in the middle or the lower middle of Main Street law, where we might get a convergence, a really nasty convergence of regulatory constraints, capital constraints, and even technical constraints because of NLP's inability, at least for the moment, to do that translation from a lay to a legal framing. So is that worrying? Is this start of real regulatory pushback worrying? And does that bode badly for Main Street law or maybe lower Main Street law, or am I being too pessimistic?
No, it's actually, and it's not the Main Street lawyers, it's the people who need lawyers who are feeling the pinch on that for sure. And I call this the Empire Strikes Back portion of the entertainment. And yeah, that's a total thing that's happening. And I would give it in two different categories, both of which are worrisome. One category is completely right. That's not just Texas. There's, I think, and Tino or Justice Cuéllar would know better than I would. I think there's 38 different states that have access to justice commissions. And a lot of what they do is standardized forms. And so order protection forms are standardized all over the country. Divorce forms, other than simple divorces, no money, no kids, are not standardized. And that's 100% because of the divorce bar. Like they pushed really, really hard on that. And that happened in the great state of Tennessee where I teach, but in Texas and all over the country. And again, that's like, I tried to speak in really broad generalities. Yeah, when you get down to narrow things, you ask yourself, is there a organized portion of Main Street lawyers who will be mad at this? And that means it's harder to get that done, basically. And so divorces are like that. That's all worrisome. I would note there's a second layer of worry. And the second layer of worry is instead of doing the blunt hammer of UPL, there's another move among lawyer regulators to say, oh, no, we don't want to get rid of legal tech. We just want to make sure it's safe. And so again, I'm not a 100% anti-regulation person, except for in this area, the regulation has almost always reflected the interest of lawyers and not the interest of the public. And so that alone makes me concerned about this broader idea. And this reminds me of the cybersecurity thing. Insofar as the legal tech is less secure than other areas, and that's bad, and that has to be fixed. Insofar as cybersecurity is a problem, no matter what you do, that trying to regulate these places on that basis would just make me nervous for the reasons I already said.
Other views in response to that question about some of these new deregulatory initiatives? Okay, let me move to a different question. We could call this the not far enough question. And it again rolls up a couple of questions that came in through the Q&A. So one person asked, wouldn't it be cheaper as a business model for courts to work in a consortia to fund basic legal delivery products, including basic legal education and orientation, than it is for them to deal with each and every case in a bespoke manner and badly? So, you know, this highlights the possibility of what's sometimes referred to as public option legal tech presided over by courts. Now, one possibility is ODR platforms, but there are other ways to think about it as well. You can imagine court overseeing e-discovery arms. So that's one version of the not far enough question, but there's another version of the not far enough question, which is, and here it is further liberalization the answer to the UK's lack of investment in legal tech, and thus a potential way to address the massive gap between supply and demand? So you have a major deregulatory effort in the UK, but maybe it wasn't enough, or is it time to consider other things? Might be the thrust of the question.
So I'll start with just a piece about the courts. Of course, courts should think more about how they can play a proactive and productive role in helping the millions and millions of people who are pro se, who are struggling with tort issues, with elder abuse, with housing cases, with small claims, with traffic, to navigate the system. I feel like there is a piece of our adversarial system that we have to kind of acknowledge as part of our tradition, and it runs through Amalia Kessler's work and others. And query how much we're going to change that, where people want their lawyer and want the lawyer to speak for them. We're not going to become an inquisitorial system. But even within that framework, it feels to me like courts have a huge responsibility. It would be sad, in fact, tragic, if they mostly stood by and just viewed this as a responsibility of the bar, other branches of government, private lawyers, private litigants themselves. I am encouraged because I see here in California and elsewhere, not only an interest in potential regulatory changes to just shake things up a little bit without hopefully losing a deep commitment to ethics and to making sure that people are not exposed to fraudulent or inaccurate advice, but also a recognition that courts have to do more, to be innovative, to be thoughtful about exactly how we meet these needs. But, the truth is, even the most well-meaning courts, they are often underfunded. They are sometimes so focused, just their leadership and meeting their day-to-day challenges, that we ought to think creatively about structures of government, pots of money, resources, innovation officers, new branches of the judiciary that are just designed to push and force us to be thinking about how courts can do their responsibility and then hopefully have some way of intersecting with everything else that's happening outside the courts.
Could I just maybe add one thought, David, so I think we clearly need a quantum leap in scale. I'm going to stay on the court's point as well. Quantum leap in the scale of the availability of neutral, careful decision-making, third-party decision-making. That's the essence of what holds all of our communities together, is the capacity in conflict to go to neutral third parties that we trust are applying the law, the rules. And we have, I don't think, really taken on the challenge of that scale. And I think, again, this is why you say we don't want to be looking at absolutely, it's just as Cuéllar is emphasizing, we do not want to be losing the sense in which that process has people feel heard, people feel dignified, people feel like they are respected members of the community, and their conflicts are being resolved. But we have to start thinking about, how do you accomplish that in the 21st century with millions and billions of people? I mean, I think I always wanted to say, look, we cannot just say we're going to try and expand what we have now, because we will never automate our existing processes to sufficient scale. And I think if we now think about the challenges we see on social media platforms, the scale is tremendous. And now we've got private technology companies that are actually trying to operate their own decision-making process. They can't do it with humans. I think, we just need a level of innovation here. I think it's quite critical, because I think as we see the fabric of our communities fraying, it's because we have not met that challenge of providing everybody with reliable, quick, neutral, dignified resolution of disputes. And I think I would like to just jump us up to a different level of thinking about what that challenge is. And I absolutely believe that there are ways to accomplish it. And yes, they will involve technology. And no, that doesn't mean handing our lives over to automated black boxes. That's not the route. But there are other paths. I'm totally confident in that. I think we need to be getting creative to build them.
John?
Yeah, so I sort of said something about this in the text as well, but I just want to pick up on one other point about regulation. So if you think about, should there be further liberalization of regulation? Well, liberalization of legal services, the provision of legal services, is pretty liberalized now in the UK. What I think it's important to understand, we've articulated a constraint on delivery of people law, which is technological. Making progress with that is going to require data, more data. The state is actually the largest owner of legal data through court proceedings, but aggregating that data indexing it, making it available, who are you going to make it available to? Because there's all this personal sensitivity associated with that data. And so actually this is a key issue, is thinking about the regulation of access to that data, not the provision of legal services, but the data that's going to be used to train the models that will provide legal services for people. And that's a very complex issue, because, on the one hand, the benefits of access to justice are clear for the ultimate user, but equally the people whose data is represented in there have a strong interest in maintaining their privacy. So that I think is an important area for regulatory focus going forward.
And I'll also note, just like we do with the profession, sometimes we think about courts monolithically, and that's a mistake, because a federal court is made to be operated just by lawyers, and by its nature, that means only rich people or big companies arrive there, or poor people who are suing a rich person and can get money from them. Like that is a limited universe of it, but that's not what courts look like in America. Like the bulk of the courts, the bulk of the litigants are poor people or middle-class people without lawyers, struggling in these sites. So, but there's a flip side to that. There's a glass half full version, which is that is where the innovation is happening. The dissatisfaction at the highest level is actually not that high. I mean, because people don't even understand why it is that more people don't get to federal court. The dissatisfaction, believe me, like if you've been to family court in the United States, or child support court, or juvenile court, or landlord-tenant court, or debt court, you don't have to look far to find dissatisfied people. Like it's a miserable, hideous experience, and people are experiencing injustice every day in those courts, and including the judges and the clerks. They hate that, and that's part of the reason why you're seeing the change, and that's the glass half full version. In the piece, and then in one of my books, I make this, what I think is a funny argument, which is you could theoretically live in a science fiction world where the courts for the poor are fairer and better run than the courts for the rich. Like if the process continues along in a hopeful manner, you could actually see that, because that's where all the experimentation is happening.
I think we have just enough time for a rider to the bigger question about public option legal tech, or the public role in legal tech, but also a rider to what Ben just left off with. And it's the following question. RE the UK, any comment on the experience of Her Majesty's online court? So anyone who has familiarity with that, maybe the UK panelist, Ben's nodding his head. Is there anything we can infer from that regarding the public role in innovation?
Well, this has been very much forced on the courts by the pandemic, and it's been I think the experience has been one that most people involved in have found surprisingly positive. So there wasn't preparation or lead-in; it just happened bang. But actually, it's sure to be a huge catalyst for innovation going forward, because it's allowed people to realize what's possible. And we're still, trying to take stock of the impact of it. So some of our colleagues in Oxford are doing research on the way in which that's affected people's engagement with the process being online.
Any other last thoughts on that? Okay, y'all, we will leave it there. Thank you to everyone for joining us. Thanks to our presenters, to our commentators. You were all absolutely tremendous. We learned so much from you. I will look forward to seeing you next Wednesday for the next installment of this. It's at the same time. I think it's even on the same Zoom link. And at that session, we're going to shift gears a little bit. We're going to talk about legal tech within the legal system, so especially lawyer-driven tools. And we're going to focus on the question of how might our procedural rules and our commitment to adversarialism need to adapt in a fast digitizing legal system. And we have just another great slate of presenters as well as commentators to tell us all about that. So thanks all. Have a great rest of your Wednesday, and see you next time.
Thank you very much.
Bye. Well done.
Thanks, everybody.
Thank you. Bye-bye.
Thanks everyone. Bye-bye.